Welcome back to Take a Break. I'm Tim Stenevec. Just this afternoon, the Supreme Court finished a hearing that began the latest round in the GOP's efforts to kill the Affordable Care Act, better known as Obamacare. The stakes here are massive. In the middle of a deadly pandemic, it jeopardizes the health care of more than 135 million Americans who have pre-existing conditions. Lydia Wheeler is senior legal reporter covering healthcare litigation for Bloomberg Law, and she's with us now from Washington. Lydia, thanks for joining us. Bring us up to speed. What do we know so far?
Thanks for having me. So that's right. The Supreme Court just concluded arguments in this Obamacare case, and two key justices on the court have indicated that the court actually might be inclined to uphold the Affordable Care Act and just tossed out the provision that requires everyone to have health insurance, known as the individual mandate.
Meaning, so they tossed it out, meaning what?
Meaning they will just cut that one provision out of the law and let all the other provisions of the Affordable Care Act remain in place.
So for all intents and purposes, it's looking like the Affordable Care Act's legality stands.
It definitely could. It could look like we could keep the Affordable Care Act after this. Chief Justice John Roberts and Justice Brett Kavanaugh both suggested that they aren't ready to toss out the entire law. Justice Kavanaugh at one point said that he thinks that this is a pretty straightforward case under the court's precedents, meaning the court would excise the mandate and leave the rest of the law standing.
It's so interesting because those are two Supreme Court justices who, of course, were appointed by Republicans, Kavanaugh most recently by President Trump, of course. What type of questioning did we hear come from justices who are on the other side of the political aisle, those who were appointed by Democrats?
Right. So actually, we heard a line of questioning that was very similar from both sides. The court focused a lot on standing, meaning do the parties that are bringing this lawsuit forward have they actually suffered an injury that gives them a right to sue here? And so we heard questions from both sides, and actually both sides seem to think that Texas and the Republican states that brought this challenge, and also the two individuals, have the standing to sue here.
So Lydia, what is this telling you about how the law was written? I mean, is it, for lack of a better term, bulletproof when it comes to being upheld?
I mean, possibly. How the law was written was something that was focused on. Some of the justices question whether or not the individual mandate here, this provision, like I said, that requires everyone to buy health insurance, is essential to the rest of the law's function, and whether Congress actually, meant for the law to function without it. But they seem to signal that they think that the rest of the law can live on.
Republicans have been fighting this law since it was enacted a decade ago. At this point, if the Supreme Court were to uphold it today, what would their next steps be in trying to throw it out?
Right. So Democrats failed to secure a Senate majority in last week's election, which means that the Supreme Court will likely have the final word on whether or not that the Affordable Care Act lives or dies here. I chatted with some of my legal scholars who are sources of mine, and they say that no one else has brought another challenge to the law, so they don't see how the Affordable Care Act, how the constitutionality of the law could be attacked in another way other than the individual mandate. So if the court here severs the individual mandate and lets the rest of the law live, it looks like we might be keeping, the Affordable Care Act indefinitely.
Lydia, we can't ignore the timing with this, right? This is happening in the midst of a deadly pandemic where hundreds of millions of Americans with pre-existing conditions could actually lose their health insurance. What are supporters of the Affordable Care Act, also known as Obamacare, what are they saying as of now?
They are saying that this would be, this would create chaos if the court struck down the law now. Like, you have over 20 million Americans that rely on the Affordable Care Act for their health insurance. As you mentioned, some estimates say that 135 million people have pre-existing conditions, and we know that the Affordable Care Act, requires health insurers to cover people despite those pre-existing conditions. And now we have coronavirus, which is, the latest pre-existing condition. So if the court really were to strike down the law here, it would be chaotic, not just only for Americans, but for the health insurance market.
Bloomberg Law's Lydia Wheeler in Washington. Lydia, thanks for taking the time this afternoon. We really appreciate it.
The biggest stories the moment they happen from around the globe. Subscribe to Bloomberg Quick Take now for insight in an instant.